Hello students, I hope everyone is ready for tomorrow's examination. So hours before the examination, I thought we could have a rapid revision into almost the syllabus of your capital market and security laws as well as security laws and capital market for old syllabus students. Okay, so for the time constraint, I have not included the entire topics. I have included the major topic which is available in both the syllabus. So first we'll discuss SEBI ICDR regulation 2018. So starting with ICDR, if the companies are divided into two major classification, private limited company and public limited company, for issue of shares, they will be having different options. So for a private limited company, there are options like rights issue, bonus issue and private placement. Private placement can again be classified into preferential allotment and qualified institutional placement. Whereas for public company, we are having an extra option which is public offer. Okay, public offer can again be classified into IPO, FPO and offer for sale. Okay, so basically this chapter ICDR or ICDR regulation is giving insight into the regulations or the compliances which are to be made by a company, made by a listed company or a company which is going to be listed while taking or while issuing shares by these methods. Okay, that means if they are going for IPO, if they are going for FPO, if they are going for OFS, if they are doing rights issue, bonus issue, private placement, etc., what are the regulations to be complied? So this is applicable only for a listed company. Okay, so the major topics which are covered in the regulations are that persons who are not eligible to make IPO, FPO, okay, that will be the promoter, the issuer, promoter or selling shareholders or the promoter group who are debarred by SEBI. Then promoters or directors of another company which is debarred by SEBI when they are directors or promoters in the issuing company also. Then promoters or directors who are fraudulent borrowers or willful defaulters, then fugitive economic offenders, and if there are any unconvertible, sorry, if there are convertible outstanding shares or securities. Okay, then for eligibility route for IPO, FPO, we are having two eligibility route. Number one is profitability route. Number two is QIB route. In under profitability route, if you are satisfying some conditions, you can go for profitability route. That is, if you are having net tangible assets of 3 crore or above, net worth of 1 crore or above, or average operating profit in the preceding 3 financial years of minimum 15 CR. If you are not complying with these conditions, you have to go for QIB route, in which you have to give minimum 75% of the offer to qualified buyers. Then we are having general conditions for IPO, FPO. You have to make an agreement with a stock exchange. All the securities should be dematerialized. Then partly paid shares should be fully paid up. Registrar to issue, share transfer agents to be appointed, etc. So these conditions, general condition, additional conditions are almost same for all the category of issue. Whether you are doing rights issue, whether you are doing bonus issue, preferential allotment, qualified institutional placement, etc. These conditions are more or less the same. Okay, then you have the minimum promoter contribution concept. That is, if you are making IPO, minimum 20% should be contributed by the promoter, and there is lock-in period also. Okay, so lock-in period earlier was 3 years, now it has been reduced to 18 months. Okay, but when the entire amount is in capital investment, when the entire amount contributed by the promoter is used for capital investment, still it will be 3 years. Then we are having the concept of fast track FPO. So for doing fast track FPO, the company, the issuer should be listed for at least preceding 3 financial years, they should be listed, and market capitalization should be 1000 CR. Okay, then we are having the rights issue, preferential issue, etc. Qualified institutional placement, IDR, IPO by small and medium enterprises, innovators growth platform, Then bonus issue. So as I mentioned earlier, for the conditions or the regulations for all these types of issues are more or less the same. Okay. Then now we are moving to the next part, which is SEBI Share-Based Employee Benefits and Sweat Equity Regulations 2021. So this is a combination of SEBI Share-Based Employee Benefit 2014 and SEBI Issue of Sweat Equity Shares Regulation 2002. So in the former, we had the discussion of ESOP, like Employee Stock Option Plan, then Employee Stock Purchase Scheme, etc. So this is the combination of these two regulations. Okay, so in this portion, we will be having employee stock option plan, stock purchase, stock appreciation right, general employee benefit scheme, and retirement benefit scheme. Okay, so for doing or for carrying out these activities, you are having two routes, direct route and trust route is there. So under direct route, the company will be, see in this topic, in this regulation, the company is giving shares to its employees or directors. Employee stock purchase or employee stock option plan or stock appreciation right scheme, it is all related to the share of the company. So the shares of the company can either be purchased or they'll be giving the same to the employees, which is in direct route. Okay, the company will be issuing the shares to the employees. But under the trust route, if the company is not having that much of shares, unissued shares with them, they will be taking the trust route. So that an employee welfare trust will be formed. They'll be taking, or the company will be giving loan to this trust. The trust will be purchasing shares from the open market, stock market, and this trust will be giving these shares or issuing these shares to the employees, beneficiary employees. Okay, so there are the stages in employee stock option plan are granting of option, vesting of option, and exercising of option. See, when you are making a difference between the sweat equity and ESOP, employee stock option plan, sweat equity shares are issued at discount or a consideration other than cash. Okay, which is given for the hard work which is rendered by the employee. But on the other hand, if you want to give shares to your employee under employee stock option plan, first you are intimating the willingness to give the shares, which is known as granting of option. And between the granting and vesting, there will be a minimum period of 1 year. Okay, so you are intimating the employee that I am proposing, we are planning to issue shares to you, so that the working mentality, the hard work, or the efficiency output of the employee can be increased. Okay, so that is granting of option. Then vesting is communicating the same to the employee. That means you are eligible to buy the shares, and if the employee is buying the shares, it is known as exercising of option. Okay, then as I mentioned earlier, sweat equity shares are issued to your employees or directors at discount or a consideration other than cash, which may be for providing know-how or making available rights in the form of intellectual property rights or any other value additions. The treatment of sweat equity shares may be either treated in P&L account or it may be treated in balance sheet. That means if you are issuing, if you are giving shares to your employee because of providing a know-how to your company, okay, so that is an asset. So sweat equity shares will be treated in the form of assets in that company. That means sweat equity shares are given in return for providing assets to the company by the employee. But if the employee has given some hard work to the company and you are giving sweat equity shares as a part of incentive, that will be shown in profit and loss account. Okay, then lock-in period will be there for sweat equity shares. Then you have the cap of issue, 15% cap of issue, etc. So these topics are discussed in this chapter. So now we'll move to SEBI issue and listing of non-convertible securities regulation 2021. Okay, this chapter, this regulation is basically having three parts: issue and listing of non-convertible redeemable preference shares, then listing of commercial paper in compliance with RBI regulation or guidelines, issue and listing of non-convertible securities. Okay, so the same topic which we discussed in ICDR are also applicable in here also. Eligible issuers in principal approval from stock exchange, other conditions like formation, deed should be there, trust deed should be there. Then you have debenture redemption reserve or capital redemption reserve should be open. International securities identification number, ISIN, should be there for your securities. And you have the concept of green debt securities also. If the company is engaged in renewable energy, then clean transportation, sustainable management, etc., they can issue green debt securities. Then now we'll move to LODR, SEBI Listing Obligation and Disclosure Requirement Regulation 2015. So under this regulation, you are having the regulations or obligation which have to be met by all the companies, which is the first part, obligation to all the listed companies. All the listed companies should follow these regulations. Okay, so the regulations will be like appointment of compliance officer, share transfer agent, registrar to issue, preservation of document regulation 9, what type of documents should be preserved in what manner, etc. Then there are corporate governance regulation from regulation 17 to 27, which will be applicable to certain class of companies, listed companies only. Okay, then you have the type of compliance, which is very important. You have one-time compliance, just like appointing compliance officer. You have quarterly compliance, the compliance system, which will be done quarterly. Half yearly compliances, just like related party transaction. Annual compliances, just like your annual listing fee. Then you have event-based compliances, which will be on the happening of any event, just like your shareholding pattern, which has to be given to stock exchange, etc. Then you have SEBI substantial acquisition of shares and takeover regulation 2011, which is your takeover code. So under takeover code, you have to understand that the target company is very important. Means if the target company, there will be an acquirer, a person acting in concert, and a target company. If the target company is listed, SAST or takeover code will be applicable. If the target company is not listed, you have to comply with the conditions. You have to comply with the section 235 and 236 of Companies Act 2013. Okay, so the conditions are, there will be, or the parties are acquirer, PAC, and target company. Okay, so whether takeover code is applicable or not will be depending upon the status of the target company. Then there is trigger point for open offer. So if a company, acquirer plus PAC, is having, or they are having shares in target company for less than 25%, and the acquisition is enabling them to exercise 25% or more voting rights in the target company, then they will have to give an open offer of 26% subject to 75%. Okay, that means if a company, acquirer plus PAC, is having shares, they are having shares of target company which is less than 25%, and their acquisition is entitling them to hold 25% or more voting rights in target company, they have to give mandatory open offer of 26% extra. Okay, then if they have acquired 25% or more, then their second trigger point will be more than 5% in a financial year. If they are entitling to exercise, or acquisition is entitling to exercise more than 5% in a financial year, they have to give additional open offer of 26%. That is a trigger point for open offer, and you are having the procedure for open offer. Your merchant banker should be appointed as manager to offer. You have to give make public announcement. Escrow account should be maintained. Then after that, detailed public statement should be maintained. Draft offer document, you will be revising the offer document, you will be dispatching the offer document. Then price review will be there. Independent directors recommendation, opening of tendering period, payment of consideration, then post acquisition public statement, etc. Then you are having automatic exemption and exemption by SEBI, which is explained in regulation 10 and 11. Okay, then your next part is SEBI prohibition of insider trading regulation, PIT regulation So you should know who is an insider and who is a connected person. A person who is having access to unpublished price sensitive information, which is the data is not published now, but when it is published, it will be having an impact on the price, which is known as UPSI. Okay, examples are financial result, dividend declaration, change in capital structure, change in KMP, merger, demerger, etc. Okay, so a person who is connected in the sense, if a person is associated during the period of 6 months prior to the act of buying or selling as an employee, as a professional relationship, if a person is having contractual employment or fiduciary relationship, that person is known as connected person. Or a person who is having access to UPSI is also known as connected person. Okay, so there will be certain persons who are deemed to be connected, just like your immediate relative, holding company, subsidiary company, your mutual fund sponsor, etc. Then restriction on communication. So generally UPSI cannot be communicated by insiders, but under certain circumstances for legitimate purpose, it can be communicated. For example, if the company want to take or avail a loan from a financial institution, they'll be asking for the financials, up-to-date financials, which is not published. So they can give, provided that the person to whom you are sharing the data, the person to whom you are giving the data, submitting the data, they will be treated as insiders, and you have to ensure that the data is not being misused. And if the insider want to trade in the shares of the company when the trading window is closed, they can always have a trading plan which should be given before your plan. Okay, then trading plan should be for minimum of 12 months. Then the period in which you cannot do the trade, there are certain period in which you cannot execute the trade, that will not be available in trading plan as well. That means just before the financial result is out and after the period in between that financial result is published, you cannot enforce or you cannot execute any trading plan as well. So you are having the disclosures in SEBI insider trading regulation, like you are having initial disclosure is there, then continuous disclosure is also there. The code of fair disclosure, the concept of code of fair disclosure is that you have to make the disclosure in such a sense that if you are making the disclosure, it should be available to everyone. So just like it should be uniform, universal. If you are making the disclosure in such a way that you are giving the information to just a selected group of persons, the information that you are shared will be UPSI itself. It will not be any public information. If you want to make that information public, you have to use any mode of communication which is universal and uniform. Then there is a code of conduct in which you are having the concept of the trading window. Trading window will be open and closed. Okay, it is not that insiders cannot trade in the securities of the issuer or the company. They can trade when the trading window is open, which is a notional concept. Okay, then there is Chinese wall policy. That means in between the departments also there should be a secrecy. The secrets or the financial results should not flow from the finance department to the HR department. That is also violation of these regulations. Okay, then SEBI prohibition of fraudulent and unfair trade practices relating to securities market regulation. You are having the concept of security law fraud, just like you're giving information, you are giving any promises, you are concealing any fact. Okay, you are giving some suggestion to outsiders. These all will be coming under security law fraud. Okay. Then SEBI delisting of equity shares regulation. There are two types of delisting. Delisting means just the opposite of listing. So voluntary delisting is there, compulsory delisting is there. Voluntary, which is again classified into three types. If you are delisting from the entire stock exchange, from all the stock exchange, it is the first part. You have to give exit opportunity for your shareholders. Number two, it is delisted from certain stock exchanges, but it is remaining on some stock exchanges having nationwide terminals. Okay, so for that, exit opportunity need not be given, and there is delisting by small companies, exit opportunity should be given. So compulsory delisting means it is a penal measure. If you have violated any provisions of the security law, in violation of that provision, the stock exchange will be delisting your concern from the stock exchange. Okay, then buyback of securities regulations 2018. So objective of a buyback may be to increase the value of shares, to consolidate the voting power, to prevent takeovers, etc. So with related to buyback, you have to comply section 68, 16 and 70 of Companies Act. In addition to that, you have to comply SEBI buyback of securities regulation 2018 if you are a listed company. Okay, so from examination point of view, prohibition of buyback section 70 is very important. You cannot buy back your own shares through your own subsidiary company, investment company. If you have made any default in payment of interest on deposit, repayment of deposit, interest on debentures, preference dividend, etc. Okay, so that topic is very important. You have to take care that that is being asked for several examinations. Then method of buyback, a tender offer method is there. Then you are having a book building method, and stock through stock exchange also you can make the buyback of securities. Then mutual fund regulations 96, you have to understand what is the concept or structure of mutual fund. There will be a sponsor, then your trustee company. Mutual fund will be formed as a trust. A trustee company will be there to manage the process of the trust. Asset management company will be there, etc. Okay, and there will be unit holders, etc. There are several type of mutual funds: open-ended scheme, close-ended scheme, growth scheme, diversification fund, etc. Then the concept of net asset value. Net asset value is equal to net asset by number of securities which are outstanding. Okay, the concept and the value, the growth of mutual fund is valued in terms of NAV, net asset values, and you are having some terminologies like KIM, SID, etc. Okay. Then SEBI Collective Investment Scheme, CIS Regulation 99. It is just similar to your mutual fund. So which is explained in section 11 AA subsection 2, 2A and 3. So any fund which is involving pooling of assets, whether it be money, property, etc. and the persons who are investing the amount is not having any control on the daily activities, it is known as a collective investment scheme. Just like your mutual fund, there will be collective investment scheme management company, your trustee will be there, etc. Okay, the same framework is applicable in the case of collective investment scheme also. Then coming to your first part, which consists of the capital market part, consists of your SEBI Act. So from SEBI Act, you should be understanding or you should be going through the several powers of SEBI, civil powers of SEBI, power to make investigation, power to levy penalty, then several penalties of SEBI under section 50. So these penalties are there in your Securities Contract Regulation Act, SCRA, and as well as in your Depositories Act also. The sections are just changing, but almost all the penalties are similar. I'm not saying that it is same. Most of the penalties are similar in this case. If you are learning the penalties of SEBI from 15A to 15HB, it will be very good that you can learn the penalties of Depositories Act under section 19 and SCRA under section 23. Then SEBI compliance redressal system is also there. Okay, then the last part of this discussion is related to securities market intermediaries. So you know that there will be an issuer in the securities market and the investor. So between these, there are several parties known as securities market intermediaries like merchant bankers, registrar to issue and share transfer agent, bankers to issue, investment advisors, research analysts, underwriters, portfolio managers. So if you want to or if you want to start a career, or if you want to start as a intermediary of SEBI, what are the prerequisites, what are the roles and responsibilities, etc. are to be discussed in this part. So as I mentioned in the first part, at the beginning of the discussion, I mentioned that due to time constraint, I was not able to include all the topics. I have included majority of the topics. So I think the discussion will be useful for your examination, which is going to happen tomorrow. Okay, I wish you all the best. Do well in your examination. All the best. Thank you.